Grange Foundation and the 1 in 1,000 Club is very happy to have our guest speaker tonight, who is a Granger, Mr. John Griffin. He is from Sarasota, Florida, formerly from the state of New Jersey, where he was the Junior Grange Mini Prince, Junior Grange Prince, and National Grange Ambassador back in 1996, I think it was, and he was in Spokane in that year as our youth ambassador. He and his wife Carrie have a elder law, which is a specific kind of law firm. He's a graduate of Wake Forest University in South Carolina, North Carolina. And he is volunteered to talk to Grangers tonight, and he has a little presentation. We're very happy that you were able to join us and share your knowledge and answer questions of folks. This is being recorded. It will be put on the Grange Facebook and YouTube sites for those that are not with us tonight. Please gather up in your mind questions. He will take questions during his presentation, and when he's done, then specifically answer as many questions as he can. So I'd like the pleasure to introduce Mr. John T. Griffin to you.
Well, thank you. I appreciate that introduction. I have the chat open for anyone who wants to post a question and doesn't feel comfortable speaking on the microphone. You can type into the chat and I'll hopefully be able to see that during our conversation and answer there. Or if anyone wants to chime in anytime during the conversation, I'm happy to take direct questions as we go along, because it's probably easier to answer them as they come up than wait until the very end to address them. So I'm gonna try to share my screen here if I can, so we can follow along. Now, before I start, I want to say that I am only licensed to practice law in Florida. And so I don't have, you may live in a state where the laws are a little bit different than they are here in Florida. So I'm going to speak to Florida. Many of the things we talk about are generally true no matter where you are living. But some of the numbers that we're going to talk about specifically with the Medicaid information are only going to be applicable to Florida. And I'll try to point those out so that you know where your laws may be a little bit different. So I'm going to get started. So when we look at why elder law and why planning is important, the statistics are not great about what our likelihood is of developing an illness that might result in needing long-term care. So using the numbers here, most of which I've gathered from the Alzheimer's Association, by the age of 65, 13% of people have already been diagnosed with some form of dementia. And we saw that, play out this week in the news with, someone like Bruce Willis, who's relatively young, clearly, experiencing some of those symptoms of dementia now for a few years. So 13% by the age of 65. By the time we hit 85, that number's about 50-50. So we have a 1 in 2 chance of developing dementia if we live to the age of 85. When we compare those numbers to, say, having your house burned down in a fire, you have about a 1 in 3,000 chance of having your house destroyed in a fire. But most people, or almost all people that have a house, are going to have homeowners insurance. But you have a 1 in 2 chance of developing dementia, and a very small percentage of people are properly prepared for long-term care planning. So despite the very obvious differences in risk, people aren't really properly planning for the fact that if we hit 85, we have a 1 in 2 chance of having dementia. So we want to make sure that when you're planning, you think about these long-term care issues and that you start early enough that you can plan. So one of the ways I like to start is, when we think about getting older, we think about where do we want to live. And most people, when talking about where they want to live, are going to be looking at home, right? Almost everybody nobody comes into me and says, oh, I just can't wait to go to the nursing home. Can you help me get there? And so most people are saying, I want to stay at home as long as possible. So talking about living at home, it's going to depend on what type of care you need in that environment, because your staying at home is often the most expensive option for long-term care. 24-hour home care is going to run you around $25 an hour. So if we multiply that by 30 days in a month, that's about $18,000 a month right now, if you were going to get 24-hour in-home companion care. So that's non-nursing assistance, just companions. So that's not doing the medicine. That's not really doing much physical contact with you. That's companion care. And one of the issues we're facing now since COVID is, even if you wanted to hire someone to come to your home, we're having real difficulty finding people to work those jobs. So if you've got a young one coming up that needs a career, nursing and companion care, there is a definite need right now. It's really turned, a lot of the nursing homes can't even fill their slots because of the demand. And with COVID, people aren't coming back to work. And so there's a real shortage, at least here in Florida, for these caregivers. The other issue that often happens when you're staying at home is that you already have a planned caregiver in the home. And, a spouse, a partner, a friend, a child who you're going to be relying on to be that caregiver for you, or you're going to be a caregiver for that loved one. And the Alzheimer's Association uses the statistic, I'm stumbling there, that 68% of caregivers fail to survive the people they're caring for a dementia patient. And that comes down to really one thing, which we know, which is stress kills, right? And the stress on the caregiver is often far exceeds the stress on the recipient. And so that stress, they don't go to the doctors, they're not taking care of themselves, they're not resting, they're not sleeping. The dementia patient wakes up every day and it's a new day, right? All those stresses of yesterday are long forgotten, but the stress on the caregiver just builds and builds and builds, and has a very strong detrimental effect on the caregiver. So we always tell families, and I've told my wife, I don't have any expectation of you caring for me in our home long term, because I married you to be my wife, not my nurse, and it's not a job that one should expect necessarily of their loved ones. So at home, obviously best choice, but most expensive. The next level of care is in an assisted living facility. And when we compare an assisted living facility to a nursing home, what I like to describe or use as a descriptor is, when you walk down the hallway of an assisted living facility, every door is closed. They are individual apartments in which you are expected to be able to live semi-independently with only some assistance. Whereas when you walk down the hallway of a skilled nursing facility, in almost every case, every door is open, so that the nurses and staff can be coming in and checking on you constantly. And every time they're walking down the hall, they should be looking in to make sure you're not on the floor. In an assisted living facility, you're not going to get that level of care. It's really a few times a day. They're going to check in, bring you down for meals, maybe, things like that, but it is not that full level of care. Since I started practicing really over the last 19 or 20 years, there has been another development in assisted living, which is what is sometimes referred to as memory care. And assisted living memory care is a lot like a traditional assisted living, but it has locked doors. That's the primary difference. It's also supposed to have a slightly higher staff ratio, but that's not always true. So in a memory care unit, you're going to find that the doors are locked so that the dementia patient can't wander or get lost. Now, in my part of the country, you're going to find assisted livings range from $3,500 to $7,500 a month for that level of care. The higher end usually being in some sort of memory locked unit. That price ranges usually from $5,500 to $7,500, depending on how fancy a facility it is. The assisted living, generally starting around $3,500, that's going to be very limited amount of care. but they are going to provide you all meals, housekeeping, and things like that. Most assisted livings, as you need more care, you're going to pay for that a la carte. So if I need to be bathed, I'm going to pay $300 a month for bathing assistance. I'm going to pay $200 a month for medication management. And so as you are in the assisted living facility, those are going to be added on to those costs. The highest level of care is a skilled nursing facility. And in a skilled nursing facility, you should be getting or have access to 24-hour care around the clock with a medical, either doctor or nurse on staff in the facility around the clock. So unlike an assisted living that may only have companion services, a skilled nursing facility should have a medical professional on staff in case of an emergency. This is often the option for those with the highest needs. Generally, when we're looking at Medicaid and what is required to get into a nursing facility, we look at what they call the activities of daily living. And activities of daily living are things like dressing, bathing, toileting, continence, eating, walking, and transferring. Those are your primary activities of daily living that we look at. And transferring means up and down out of a chair or bed without assistance. So that skilled nursing center is usually going to be a facility, if any of you have ever been in rehabilitation, like after a broken hip or a knee replacement, that rehab facility is usually also a skilled nursing facility that provides long-term care. So this is going to be the most expensive option for placement versus home care, let's say. In Sarasota County, those numbers are between $10,000 and $14,000 a month for that level of care. Now, before COVID, we were telling people between $75,000 and $10,000 a month. But in the last 2 years since COVID happened, those prices have jumped significantly, more than 25% in many cases, in part because of staffing issues that they can't keep the facility staffed. So they're having to pay very high salaries to keep those facilities staffed. Also because of additional precautions, lockdowns, difficulty getting supplies, all of those things have driven the prices up dramatically. I don't expect to see those prices drop, to be honest, after COVID's sort of an endemic instead of a pandemic, because once they're getting that price, they're not likely to reduce it. So those are kind of give you pricing and options for that. And I do see that Michael Martin posted that assisted living in Connecticut is about $8,800 a month, plus the a la carte, as needed. So more costly than Florida, definitely. And so you just take I-95 down over to I-75 and you'll be here. But it is very expensive up north. And so I would assume if assisted living is running you $8,800 a month, then your skilled nursing home is probably going to be twice that because of the level of care that's required. So I always like to add in housing option number 4. This is the cruise ship option. According to that website I listed there, it's about $100 a night per person. So that's only $3,000 a month. So you could get on that ship, ride it around all year. You've got all your meals will be included, including lobster and steak night. You've got gambling on board, shows on board, different port every night. So a lot of options there if you want to get on that cruise ship and just live aboard. But let's talk then about how do we pay for this. One option that most over 65 individuals have is Medicare. So Medicare, many people think, well, I've got Medicare, and I've got maybe a supplemental insurance. It covers all of my needs. The reality is Medicare doesn't pay for what we call custodial care or long-term care. So what Medicare will cover, and when we talk about Medicare, I'm talking about the rehabilitation benefit in this example. Medicare will cover up to 100 days of rehabilitation. So if you have a stroke, a broken hip, injured back, surgery, after 3 nights in the hospital, they will cover up to 100 days. When looking at those 100 days, Medicare picks up 100% of 20 days and 80% of 80 days. So you are responsible for 20% for 80 days on your Medicare benefit. that runs around 190, roughly $190 a day. So let's just round that up. 200 times 80 is $16,000. So I think if I did that math right. So if you have to pay that, that's a big, some amount of money to come up with cash. So what many people have is a Medicare supplement. And one of the things in a traditional Medicare supplement is that they pick up that 20% for those additional 80 days. So you can get up to 100 days of no cost rehabilitation benefit with a traditional Medicare supplement. And so the warning here, though, is that you would not, if you have switched to a Medicare Advantage plan, you have potentially given up those benefits. So a Medicare Advantage plan is a Medicare alternative where you negotiate for usually a lower rate or no fee at all. And they provide you all sorts of additional benefits like gym memberships and eyeglasses. But one of the things you often give up when switching to a Medicare Advantage is that 20% coverage for those 80 days. And so if you have a Medicare Advantage plan, you need to make sure you understand what benefits you have given up in order to switch that insurance. Because if you have given that up to save $40 a month and end up having to pay $16,000 in rehabilitation costs, you will find you did not make a good, choice there economically. So if you have a Medicare Advantage plan, you want to look at that, call the company, and understand what your rehab benefit is, because that broken hip can suddenly become very expensive if you suddenly have the need or that emergency. So Medicare Medicare is health insurance. So just like you had when you were working, it is traditional health insurance and does not provide any long-term care benefit. The other issue with that 100 days is you don't necessarily get all 100 days. If you go into rehabilitation with a injured knee, you may only get 20, 30, or 40 days of coverage until you're back on your feet. They can end that 100 days at any time during that rehabilitation process once they feel like you've maximized your, recovery. So when we look at Medicare, it's not going to cover this kind of care. So now we have to look at alternatives to pay for that. And option number one is there's not a facility in the country that's not just happy to take your money, right? At $12,000 to $14,000 a month, they'll be happy to collect that from you in cash, check, IRAs, sell your art, sell your jewelry. They'll take it at any way you want to. But most people, if we can avoid it, don't want to have to pay that money out of pocket. So we're going to talk about a few ways that we have available to us. One of the things you want to think about when you are private pay is it can have a accelerated impact on your finances. Because if you have money right now that is generating income for you, let's just say you have a stock account that generates $10,000 a year of income that you rely on. As you spend those assets down on long-term care, you're also going to be losing that income. So then as you lose that income, you need to use more assets, which means the money goes down at an accelerated rate. It's not a slow, steady decline. It can be a very sharp decline as you lose income and spend assets. So even though you may feel confident in the amount of money you have, it's sometimes not anticipated spending $200,000 or more a year on skilled nursing home care. So option number two, if you have it, or if you're one of the younger participants on the call, would be to have some form of long-term care insurance. Now, long-term care insurance comes in many forms and has many different coverage levels. So if you have long-term care insurance, this is the type of insurance you can't get if you need it, right? In order to get long-term care insurance, you have to buy it early enough that you don't have medical issues, don't have an apparent need, because once you need it, they won't give it to you. So my wife and I carry long-term care insurance. I hope to not need it for 40 years, but I don't know, right? If I have a stroke tomorrow and suddenly need care, I'll be covered. But you have to plan early enough to get it. If you have a policy in existence already, you want to evaluate a couple things. One is, how are the benefits paid? Some are paid daily, some are paid monthly. When you look at your daily or monthly amounts, you then want to look at how much coverage do I have. So if you have a policy that pays $250 a day, for 3 years, then you will be covered 3 years at $250 a day. Most policies that are written now actually don't work that way. What it says is, I'm going to give you, and I'm going to pull out a calculator here, $250 a day times 36 months, so 3 years. Times 36. Let me do it differently, sorry. 250 times 36. I'm just going to do it roughly, 36 times 30. So they might give you a policy that's worth $270,000. And the maximum benefit is $250 a day. So if I end up going into an assisted living facility that costs $200 a day, I might be able to stretch that long-term care insurance beyond my 3 years, right? I might get 4 years out of that. I have $270,000 to spend over the time I need to claim it. My policy, for example, also has what's called inflation protection, right? Because buying $250 today may not cover me in a nursing home 40 years from now. So every year my policy goes up by 5%. That increases my available benefit. So by the time I need that policy, I'll have a large enough pot to match the inflation, hopefully, that the nursing homes are doing. It's just important, a lot of people tell me, well, I have long-term care insurance. Then I ask them what their coverage is, and they don't know. They can't tell me what their daily amount is or how long it'll last. You need to know those things if you have long-term care insurance, because if I only have $80 a day and the nursing home right now is $380 a day, then I still have a huge gap that I need to cover under my long-term care insurance. So think about that and make sure you understand what your policy provides. The other piece I'm going to just tell you to look at in that long-term care, if you have it, is what kind of coverage it allows. The original policies that when long-term care insurance first came out, they were called nursing home policies, and they only covered that level of care. Almost all of them now have switched to allowing home care or assisted living, in part because it's, in some respects, cheaper for the long-term care to keep you at home than paying the full maximum amount every day. But some policies still are just nursing home. So you need to know what your policy covers. And you can go right back to your broker to find that out. They should be able to answer these sort of 5 questions that I've listed there pretty easily. Next option would be VA benefits. In order to qualify for VA benefits, before I move on, any questions about long-term care insurance? I can't see everybody's heads, so you'll have to either chime in on the microphone or the chat if anybody has a question.
Yeah, I guess this is Glenn here from Pennsylvania. I'll ask you a question because,
Sure.
real quickly, a lot of what you've talked, I'm living right now with a parent.
Okay.
Not that they have long-term care insurance. I'm just looking at all the bubbles and piecing them together and trying to mitigate our way through it, and we'll see where the end comes to. But that's what made me attend this tonight, just to listen and learn.
Right.
I know you're not a broker or nothing, but is there any certain companies? I'm sure you can't recommend nothing, but is there any certain companies out there that stand out as viable companies to look into for long-term care?
I will say I'm not a broker. I have my particular long-term care insurance with Northwestern Mutual because of their long history of reliability. When I was shopping for long-term care insurance, it is one of the big issues, Glenn, that we deal with, which is several of the companies went bankrupt, right? They simply did not adequately prepare for how long people were going to live. And so their numbers were all wrong. And they did one of two things. They either went belly up and some other company had to take over those policies, or they simply raised the cost on individuals so high that it was,
Not
people couldn't keep it.
justifiable.
Yeah. So I went with Northwestern Mutual because they have a long history of reliability, but I can only tell you was my personal choice. I really don't have a company to give you that would be
May
perfectly.
may I ask where they're based from?
Northwestern Mutual is a nationwide company.
Okay.
I don't think you'd have any trouble. It may, no, let's see. Let me see.
The only reason I ask is for myself and on behalf of everyone that's on this Zoom meeting here.
Yeah.
Is it just gives me something to investigate and do some research on.
Yeah, Northwestern Mutual is based out of Milwaukee, Wisconsin.
Okay.
But they should have, firms in every state. I think they represent
Okay.
nearly every state. I
Okay.
can't speak to Hawaii, Kirsten, but almost every state continental. So yeah, that was my choice when I was looking for coverage. But again, I don't work for them. No kickbacks. That was just my experience. Michael, is that answer your question, Glenn?
Yes. Thank you.
Okay, great. Michael asked, by what age is long-term care too expensive to buy? There isn't really a maximum age. He said 40, 50, 60, 70s. Once you get into your 70s, what you start to risk is not meeting the health criteria, right? Once you get sick, you get diabetes, stroke, high blood pressure, they're going to start either increasing the premiums too high or just denying you altogether. So the trick is really to start before you start going to the doctor to complain about all those ailments that you've got, because once you start a medical record that makes it look like you're going to need long-term care insurance, then they're not going to provide it to you anymore. So you need to get that in advance, really no age in particular. There are different types of policies. You can, for some of you that may have large IRAs, you can buy a long-term care sometimes within your IRA and use, say, $100,000 of capital to buy $150,000 or $200,000 of long-term care. So that type of policy allows for less healthy people to buy long-term care insurance or older people to buy long-term care insurance, because in some respects you're self-funding the first chunk. So the companies are more forgiving in their grants of insurance because they know you've already paid in a chunk to cover potential need. Whereas if you're going to pay only $400 a month, it's going to take them a long time to build up enough capital to be able to pay your insurance. So by the time you're 70, you're going to have a premium that's so high because they've got to insure against that risk. So that's why sometimes putting capital in through that type of policy will allow you to get coverage and sort of double your money or increase your coverage with a chunk like an insurance. In addition, that IRA has the potential for not being taxed if you use it for long-term care purposes. So they're trying to encourage people to buy it. So when you draw that out, you're not paying the income tax on that. I did skip the elimination period. That simply means, sorry, Ellen from Pennsylvania asked, can you please explain the elimination periods? That is how long you have to privately pay. So if I go into the nursing home, I may have, for example, my policy is a 90-day elimination period, which means I'm responsible for the first 3 months, then the insurance kicks in. It's not first day coverage. Often the policies will include that once I get to 90 days, they may reimburse me for the 90 days that I was private pay, but you've got to find out from your individual policy whether or not that gets reimbursed. But a lot of times it's a 90-day elimination period. Those elimination periods work one of two ways. One is lifetime elimination, so 90 days collectively over my lifetime, or some are 90 days per period of coverage. So I'm covering 90 days every time I want to use long-term care. If I go off of it and come back on, I have to pay again. Others are collectively 90 days throughout your lifetime. Okay. So any other questions about long-term care insurance? No. So let's talk about VA. Oh,
I'm gonna
sorry.
ask one other question.
Yes.
I'm gonna ask one other question yet. Is there any certain age range when an individual or a couple should consider looking at long-term care? Because long-term care is probably like life insurance. The longer you wait in life to buy life insurance, the more it's gonna cost, because the closer you're getting to basically, death.
Right.
So
Yeah,
it's just-
what I would say is that, I bought mine in my 30s. Of course, I do this and I see you don't have to be 85 to need long-term care. But it's just like you said, the younger you start, the cheaper it's going to be. And and the more likely you are to be eligible, because it's not uncommon. A lot of 30, 40, 50-year-olds get diabetes, and now you may not be eligible for long-term care if you've got diabetes, because your risk of getting an amputation or something like that goes up. So they're not going to cover you. So yeah, I would say start as early as you can afford to pay those premiums.
Okay.
Yeah. So then looking at VA as an option, there are generally going to be two people who are looking at VA. One is the veteran themselves. The other is surviving spouse. In order to qualify for VA, we're always going to look at the veteran's eligibility, and that is going to have to be honorable or not dishonorable discharge. So long as you have a discharge that is other than dishonorable, you can qualify for VA benefits. Now, the VA benefit I'm going to talk about is particularly what we call the aid and attendance benefit. That is the benefit that covers long-term care. There are many, many programs under the VA, and we can't cover them all here. So I'm going to talk about the one that particularly relates to long-term care. But so you have to be other than dishonorable. You have to have served at least one day during a period of war. And that is going to be World War I, II, Korea, Vietnam, Gulf War. The dates of war are often broader than people think, right? It's not when it was covered on the news. It was when Congress declared the war began and when Congress declared the war is over. So for example, the Gulf War started in the 90s and it is still going on today. So we have been in a constant state of war since the late 90s. That means every veteran who served from 1990s to now, active duty, has been a wartime veteran. Even if you served peeling potatoes in the Tampa Bay, you are still a wartime veteran if you served during that wartime period. So know that you want to check the actual dates of war. My website, which is available, but it's griffinelderlaw.com, and I'll just stick that in here. I'm going to stick it in the chat. That website, in what I call the resource center on that webpage, has a link to the VA dates of war. So you can check your service against those dates to see if you follow in a wartime zone. A lot of our clients now are getting into that age group where people serve between Korea and Vietnam. So there is a gap there between, late 50s, early 60s, where some people could have done their 2 or 3 years without there have been a war going on. So you do have to check those dates. And again, only one day. If you got in on the last day of the war, that's okay. That still qualifies. Financial criteria for this program, the rules changed in 2018, became much more difficult to get VA benefits than it used to be. But the average rule for VA is having a net worth of $138,000 or less. You'll see it's 138,489 or less. So the VA, we used to be able to get every veteran benefits by moving money out of their name to family or individuals like that. That's no longer the case. They have, in 2018, they've changed those rules to make it harder to get these benefits. So now there is what we refer to as a 3-year look back on transfers. So if you were looking to get VA benefits, you basically have to plan, either be below the $138,000 limit, That does usually exclude your house, but $138,000 of other assets, and or transfer those assets out of your name and then wait the 3 years to get those benefits. In looking at the VA aid and attendance requirement, you'll see on the, well, I can't tell what side it's going to be on for you, but over my head, you'll see the rates for 2022 of what the VA will pay you if you meet the criteria. And for a single veteran, that's a little over $2,000 a month. For a married veteran, it's $2,431 a month. And for the surviving spouse of a qualifying veteran, it's a little over $1,300 a month. Now, in order to qualify for that benefit, you have to also meet certain income criteria. I just want to see here if no, okay. The income criteria for VA aid and attendance basically says that you have to be spending your income in order to get the added income, right? So to use an example, if I make $2,500 a month in Social Security, and that's my only income, and I'm spending all of that on an assisted living or a home companion or adult daycare, then the VA, if I was a single veteran, would kick in another $2,000 a month to either help me cover those expenses or additional expenses that I might have, like maintaining my home, eating food, getting prescriptions. So you have to spend your income first, then the VA will give you this aid and attendance kicker, if you will. In order to qualify health-wise for VA aid and attendance, the general rule, you'll see I put all 4 options there, but the general rule is you need the assistance of another person to live safely in your environment. So it has a lower standard than Medicaid, which I'll talk about in a minute. It's really, if I'm a flight risk, a wandering risk, if I wouldn't know to check expiration dates on the food, because I can't remember to do that, if I don't know how to make a sandwich in my kitchen, if I don't shower, if I can't button my buttons or put on shoes, I'm likely to qualify for VA aid and attendance under those criteria. Now, for this benefit, the disease does not have to be VA related, right? So my dementia or Parkinson's doesn't have to be associated with my service. If you served, particularly in Vietnam, although some of our vets coming back from Gulf War have similar things, but if you served in Vietnam and you get Parkinson's, diabetes, there are a list of conditions that the VA automatically accepts responsibility for having given you those diseases, right? You've heard of Agent Orange litigation. If you get Parkinson's and were boots on the ground in Vietnam, you likely qualify for coverage under disability rules, which are much more generous actually than these aid and attendance. So if you do qualify as a boots on the ground veteran, you want to be enrolled with the VA, telling them about your circumstance so that they can tell you what other benefits you might qualify for. Questions about that aid and attendance benefit? No? Okay. I do want to just emphasize again, this is also true for surviving spouses. If you were the last surviving spouse of a veteran, you then may be entitled to that $1,300 a month. So make sure that you don't ignore these benefits if your last spouse was a veteran and you were their last spouse. I don't see any questions, so I'm going to talk a little bit about Medicaid. Now, Medicaid is the most state-specific program. And just so you know, after I get through Medicaid, we're going to talk about estate planning documents, which I know is the other piece here. But Medicaid is the program that provides potentially full care for that nursing home cost, right? So in Florida, if you were a client of my firm and your spouse needed nursing home care, we live in a state that has probably the most generous Medicaid program in the country. So we're a little spoiled down here. But what I can tell a lot of my spouses is that I can protect 100% of your assets and potentially all of the well spouse's income, and sometimes all of the ill spouse's income, meaning the government will pick up to 100% of that nursing home cost. So for a lot of my families, they are not paying that $12,000 or $14,000 a month for nursing home care. Now, your state may not be as generous as Florida is. I have to lay that out there. But do not assume that you are going to have to pay all of that yourself. And regardless of what state you live in, if you find the need for nursing home care becomes a necessity, find an elder law attorney in your area. Do not just go to your traditional estate planning attorney. Do not go to the person who did your real estate closing. Elder law is a very, very specific area of practice. Giving you an example of, in Sarasota County, there are probably 150 estate planners, and I am one of 5 board certified elder law attorneys. So many people do wills, powers of attorney, things like that. Very few of those people do the type of planning I'm talking about here. So it's worth it for you to go to see the expert. Okay, I'm sorry, I was a little far from the mic, I guess. Is that any better? Okay, so I'm going to put a website in the chat. That's the organization that the National Academy of Elder Law Attorneys, NAELA. I believe it's .com, but it could be .org. But NAELA is the National Academy of Elder Law Attorneys, and that is a group where people will self-identify as elder law. Yeah, NAELA.org actually. So NAELA.org. Let me put that in the chat. That is, if you have this need and you are in Pennsylvania, you should be able to pull up a local elder law attorney that would self-identify as having the knowledge and skills to do this. Not every state has board certification in this area. So, you want to find somebody, obviously, when you interview them, that explains to you how many times they've helped families go through this process. Because many people will say they do it, even though they may just be, you may be their first client. So there's no restriction that they can't call themselves elder law attorneys, even if they've never done it. But with Medicaid, generally in every state, you are going to be looking at 3 potential, Medicaid's going to evaluate you under 3 potential categories. The first is health. So in Florida, we have what they call a CARES team, which will identify whether or not the applicant qualifies for Medicaid medically. I mentioned earlier that you need assistance with what they call the activities of daily living, or ADLs. And those ADLs, like I said, dressing, bathing, toileting, incontinence, walking, transferring up and down out of a chair or bed, eating, they are generally going to require that you need hands-on assistance with at least 2 or 3 of those activities before you would qualify for nursing home. But if you're in a nursing home, you almost certainly qualify under those activities of daily living requirements. The next is going to be income. Florida is what they call an income cap state, and not every state that is what they call an income cap state. So in Florida, we have a maximum income permissible of $2,523 a month. What that really means is that if you make more than $2,523 a month in Florida, you have to create something called a qualified income trust. I think some places they call it a Miller trust. And you have to move money over every month from your account to this new bank account where it gets washed off. I call it government ordered money laundering. And then once it gets washed off, you're going to pull it out every month from that account. So that account shouldn't really grow. It's just put it in the new account, take it out. Why do they do that? If I was being cynical, I would say it's because if you don't do it, they can deny you benefits. And if they can deny you benefits, it saves them money. So there are many states who have not adopted that rule, but Florida does, and many other of your states will have too. And the most important takeaway there is you need to make sure that you have a power of attorney adequate to create that kind of trust if you have this need going forward. In Florida, it requires a special power of attorney, which many people don't have. So again, we run into problems when we try to get them benefits and have to jump through some very expensive hoops to try to get that qualified income trust created. So know that you want to make sure you have an up-to-date power of attorney, having talked to an elder law attorney who will tell you whether or not you even need this, but if you need it, that you have the authority to create it. Lastly is an asset requirement. Most states use the $2,000 asset limit for the applicant. That's pretty standard. That usually does not include a home, although there are some states that are more difficult. I'm thinking Ohio, Pennsylvania, those are a few that come to mind that have some pretty strict rules about the house. In Florida, your house is 100% protected. So here, both during your life and after death, they cannot take your home. It's why O.J. Simpson bought a house here in Florida when he didn't kill those people, because he sold everything he had in California and Las Vegas, moved to Florida, bought a big house with all of his money, and they couldn't collect against it because it was in his house. So Florida, we have extra protections. There are a few other states that have what they call homestead protections, different than the tax protections, but homestead creditor protections. But you'll have to find out in your state whether or not your house is a completely protected asset or not. There are some states, again, I'm thinking Ohio comes to mind, where even if you're married, I don't think they protect 100% of the house. So it gets very complicated in those states that are less generous than Florida is. The community spouse, so the well spouse, if you're married, I'm going to switch to the next slide here, can have $137,000 or less. So often we think of Medicaid as a program for the poor, but even without any additional planning, you're protecting $137,000, you're protecting the house, and often you're protecting the IRAs without any additional planning. So you might have, let's just make up numbers. If you had $500,000 in an IRA, a $500,000 house, and $130,000 in cash, that's $1.3 million, and you still qualify for Medicaid without any planning. So the takeaway from that is, don't assume you're not eligible, right? Just because you have resources. Talk to an elder law attorney, find out what counts that you own that counts and doesn't count, because you might find that you are already eligible without much planning. I did mention a little bit that in Florida, we have some additional planning strategies, and every state has strategies. One that a lot of people have heard about with Medicaid is gifting and what's called the 5-year look back. Medicaid traditionally punishes transfers of assets out of your name into the name of a non-spouse. So here in Florida, you can though give 100% to your spouse with no penalty. So there is no 5-year look back for transfers between spouses. So that's one thing. The program is really designed to protect that spouse at home. If you give money to your children or your best friend, that is going to be subject to a 5-year look back, which Medicaid will penalize you for, and they will look back 5 years. And if in Florida, for example, if you give away $9,000, they impose 1 month of ineligibility. So for every $9,000 you give away, 1 more month that you won't get benefits. One thing people often confuse is there are tax rules that allow you to give $15,000 away a year, for example, without paying any gift tax. But that does not apply to Medicaid. So you need to know the differences before your kids, if you get a call from your kids and say, Mom, I heard on TV you're supposed to give me $15,000 a year. Know that if you are thinking you're going to need Medicaid in the coming months or years, that you may not be allowed to do that under the Medicaid rules. So it's important that you know that and know what your circumstances are before you give any money away. In Florida, again, we have rules that allow us to own income producing property that's 100% protected. We're allowed to do annuity planning that's 100% protected. The annuity strategy is a good one that's used in many states. Again, work with a local elder law attorney to find out what your home state allows. And even if you have $1.5 million, $2 million, don't ever assume that you would not be eligible for Medicaid. If you or your loved one needs that care, talk to someone about what is available to you locally. Because even if they have a 5-year look back in your state, which almost every state does, that may mean you are privately paying, for 5 years. So let's say $100,000 out of pocket after income, you can still cap those expenditures at 5 years or 500,000 if you're above that number, and still protect assets for you, your spouse, and your kids. So just know to plan ahead. What should you be doing now? We'll talk about estate planning. Any other questions about Medicaid before I move on? No?
Is,
Oh, yeah.
this is Glenn from PA. Is
Hi,
there,
Glenn.
is there any particular website or any place that you could direct somebody to read upon this stuff for their particular state? Just ask.
Yeah, your best bet would be to go to NALA, find a local attorney, and search the websites, because there are some very complete websites out there for some of this information.
Okay.
Because it is so state specific, there isn't one sort of general place to go to get specific information, because every state is so different. You really do want to be looking locally to determine what's right for you in your community.
Okay, thank you.
Okay, no problem. So any other questions about Medicaid? No? All right. So when we look at what we should be doing now, we want to be thinking about the basic estate planning documents. For everyone, that means a durable power of attorney, a healthcare directive, generally with a living will, and a last will and testament. Every person, regardless of your age, should have those basic documents. And then, you know, it's whether you're 24 or 84, power of attorney, healthcare directive, living will. We'll talk a little bit about trusts after this, but those, whether you have a trust or not, you're still going to need a will. So everyone should have those basics. To me, one of the most important documents that you're going to have is that durable power of attorney. A durable power of attorney is a document that names an individual or individuals to step in and help you with your financial and legal matters. So it's going to be paying bills, getting your mail, dealing with insurance companies, dealing with your taxes, your income streams, signing a contract, signing you into a nursing home if that becomes it. Anything financial or legal is going to be dealt with by your power of attorney. It should be durable, because a durable power of attorney is one that lasts beyond your incapacity. So there are durable and non-durable powers of attorney. Almost everyone you're going to see is going to be durable, meaning whether I'm competent or not, this is in existence. In Florida, a power of attorney is effective immediately upon signing. So if you come in today at 34 and appoint your wife as your power of attorney, she could go out tomorrow and use that power of attorney. Some states allow what they call springing powers of attorney, which says this power of attorney does not come into effect until I'm incompetent. So if a doctor says, two doctors say I'm incompetent, then the power of attorney goes into effect. So you have to know, again, the state laws, whether or not it's immediately active or active at some point in the future. But, here in Florida, everyone's active. It really has to do with the banks not wanting to be responsible for determining whether you're competent or not, right? If you sign a power of attorney here, it's valid. Your child, spouse, friend can go in and use it. A power of attorney does not remove authority from the grantor. So if I give power of attorney to my wife today, I can still go out and do all of those things that I could always do. She is just what we call concurrently authorized to do it. And that is important because it is different than a guardianship. And a guardianship is where a court will take away your rights to make those decisions yourself and give them to another person. So a scenario where a power of attorney may not be enough in the future is, let's say I have dementia and I meet a very nice African prince who wants to share with me his fortune if I simply send him $5,000 in gift cards. And if I lack the capacity to know that I'm being scammed, then a power of attorney might not be enough. you may have to go and get a guardianship to remove my rights to be accessing my bank accounts so that I don't do damage to myself and my finances. Many powers of attorney do not have adequate authority to do the long-term care planning I just discussed. In Florida, we have a very stringent durable power of attorney law that was updated in 2011 because of our population, right? We have more than our fair share of senior citizens as citizens. So we have a very strict rule so that people don't get taken advantage of. But in Florida and in many other states, a simple one-page document, two-page document is potentially inadequate to do the kind of advanced planning I'm talking about. To give you an example, for better or worse, and I know for a lot of people it's worse, our power of attorney is, I think, 19 pages long. And that is in part because Florida requires a very detailed power of attorney, but it's also because we want to make sure our families can do all of these things I'm talking about. And many simple internet-based powers of attorney, even some attorney-based power of attorneys, are not going to be adequately granted adequate authority to do long-term care planning. So make sure, again, if you have a very simple power of attorney, you check with an elder law attorney to see if that's good enough in your state to do what needs to be done. When we talk about who should be named, you can generally name your agents in one of three ways. Individually, so A, then B, then C. You can name them jointly, meaning A or B. I don't care who does the, A or B mean, I'm sorry, A and B jointly means they have to work together. Or A or B, meaning I don't care any of the above, right? So if I name my sister and my wife, either one of them could come in and pay my bills, deal with my financial affairs. So that's, in many states, those are your options for naming agents. And you also just want to make sure that they're very trustworthy because you are giving away the keys to the store. So you have to trust that anyone you name is going to be looking out for your best interest. I tell her a story that was a true story, happened in my practice. Client came in, told me they wanted to do a new power of attorney, wanted to name their son as their agent, which makes sense. Her son was actually going to come live with her in the future, very near future. So she thought he was the best person to do the job. When I asked when was he coming to move with her, she said as soon as he gets out of prison. And so that was not a good choice for a power of attorney, because if you can't rely on that person not to steal from you, do not give them the keys to your financial future. Any questions about that power of attorney? No? Okay. So the next documents that we'll talk about, and if you do have one, just chime in or go to the chat.
John, I have a question,
Yes.
please. On the slide before,
Yes.
item under things to consider,
Mm-hmm.
things to consider, does it include the power to make unlimited gifts? Now, how is that different than what you talked about, the $15,000 gifts? Is it different?
Well, it is different. So in many states, the power has to be explicit about how much gifting can be done. Many powers of attorney authorize gifting up to that $15,000 or whatever the IRS number is in any given year, but do not allow for unlimited gifting. And if you need nursing home care and want to protect, $500,000, you may want to transfer those assets to your beneficiaries, your kids or your loved ones. And if you don't have the ability to make those unlimited gifts, you will not be able to make that transfer. And therefore you will not be able to protect those monies for long-term care planning purposes. So you want to make sure that it has unlimited gifting power if you want to have long-term care planning as part of your future. So if you have a power of attorney, you do want to check that. And again, if it limits it to the tax rules, that's generally not adequate to really protect this money going forward. Okay. Any other questions about that? No? Okay. For healthcare purposes, there are really 2 or even 3 documents that deal with our healthcare decision-making. The first is what we call an advanced directive for healthcare. This is a lot like the power of attorney, except for our bodies, right? Who's going to step in and talk to doctors, consent to surgery, treatment, rehabilitation, medication management, all of those normal day-to-day decisions that are part of our medical decision-making. The second part of that, though, is commonly referred to as the living will. And the living will is the part of the document that says what happens at that last 1%, right? What we commonly refer to as pulling the plug. Can your agent or surrogate withdraw life support? That may include artificial heart, lung, dialysis. It often includes artificial nutrition and hydration. In our particular living will, my practice exclude, I can only speak to my practice. I have expanded what a living will covers to include things like, I like to say it this way, I don't want to be the healthiest person in the dementia unit, right? So if I'm in a dementia unit, my wife is authorized to take me off blood pressure medicine and heart pills and maybe even insulin, or turn off a pacemaker, because I do not need, if I have no quality of life, more days does not matter to me. So you want to make sure that your living will adequately reflects your individual wishes about how much authority you're giving to your surrogate. One other difference in our living will than you might see from one you have is that our living will is very clear that the decision ultimately falls to family or that individual you've named to make that decision. Many of them are written to say that if I meet these criteria that the document provides, then the doctors are to turn off life support. That is not traditionally the way people understand the document to be. Most expect their family to be consulted and have some say in that decision-making process. Because with COVID, for an example, if you have a living will that says, if A, B, and C, then take me off a ventilator, that may not adequately reflect your wishes. If there is some off chance that you might get better, you may want them to keep that ventilator going for 3 weeks until you recover or don't recover to a certain degree, and then they can terminate that life support. So you just want to make sure your living will is well thought out and adequately reflects your wishes. And it also is very important that that person have the same philosophy about end-of-life care that you do. I like to say, if your daughter has a 21-year-old cat on insulin, they're probably not going to pull the plug, right? They're not, if they have a difficult time letting go of loved things and you are a loved thing to them, then it's conceivable that you will be kept on care long beyond your desires. And so make sure that the person you pick has a philosophy that matches with yours so that they can make that decision as you would make if you were able. The other important thing that I tell families, and one of the reasons Joan planned this at this time of year, is because many of us will get together with our families in the coming week or two as Easter approaches, if you celebrate Easter. And it's important that you just talk, when we do this around Thanksgiving, we say talk turkey, right? But, just lay out your wishes. This is an impossible decision to ask someone to make, right? I want you to pull the plug on me and let me die. No one has an easy time doing it, no matter what your situation. So you want to make sure that you have told the people your wishes so that they can simply do what you've asked them to do instead of feeling like they have the weight of that decision on their own, right? If you are in a coma and they have to decide whether or not to pull the plug and you have never mentioned to them what your desires are about end-of-life care, that decision is 10 times harder for them. If instead they can say, you know what, mom always said, if she was in a coma, she would not want to be alive, laying in a bed for 3 years. I feel good about pulling this plug because it's what she told me to do. That is a gift to your family that you absolutely should make. If your family then says, which we hear a lot of times, I'm not going to talk about this. Mom, that's so morbid, or Dad, that's morbid. I don't want to talk about this. You tell them, if you can't talk about this now while I'm healthy, how are you ever going to make this decision when I'm not? And if you can't talk about this now with me, I'm going to have to find somebody else to do this job. Because if they are not up to the task of having this very difficult conversation while you are well and going to survive the conversation, it will be impossible for them to do that while you're laying in the bed, likely to die at the end of that conversation with the doctor when he pulls the plug. So do that, make that gift to your family. The one other document that's not listed here, but you often hear about, is what's commonly referred to as a DNR, or a do not resuscitate order. A DNR is not listed here because it is not a document prepared by a lawyer. It is a document prepared by a doctor. So a do not resuscitate order is a medical order issued by your doctor that says, do not perform intervention in the event I stop breathing or my heart stops beating. I do not want CPR. And so a lot of times people come to me in their 60s and 70s and say, well, I have a DNR. And then I ask them, so if you drop to the ground right now and stop breathing in my office, would you want me to call 911? And if the answer to that question is yes, then you are not ready for a DNR, because the DNR says, do not revive me, do not touch me, let me pass whatever's happening. What's scary about that is, one, the client didn't understand what they were getting when the doctor gave it to them. And in my opinion, the doctor didn't understand what they were signing when they signed it. Because if you can't have that basic conversation with your patient to say, are you telling me if you dropped here in this office, you wouldn't want me to perform CPR? Most people say, oh no, I would want you to do that. Then you're not ready for a DNR. You can always get a DNR later in the process. Generally, a DNR is appropriate when you're in a skilled facility, when you've made the decision that you're ready to go if something happens, or if you have an advanced illness like cancer or Parkinson's or Lou Gehrig's, where you just say, I wouldn't want to come back another day if my heart stopped, let me go. Questions about that document? Any of those documents?
John, you have 2 questions from Michael in chat.
Okay, great. Thank you, Michael. The question is, if I have a healthcare directive that includes end-of-life instructions, is that the same as a living will? Yes. So in our particular case, we merged those 2 documents into one, probably like your lawyer did. You can have them combined in one. So long as it covers end-of-life decisions, you should be fine. The second part of the question was, that makes me believe that's what I have. I was wondering if a living will was a separate document. Sounds like it's the instructions that are included within the healthcare directive. Yes, like I said, a lot of times it's just one document, usually broken down into different parts, but your healthcare document can include both the normal decision-making and the end-of-life decisions. But for a lot of you, that would not be true. It would be 2 separate. But yes, Michael, I think if it covers both, you're good. Any other questions about healthcare directives? Okay. The next.
Excuse me. Yes. I have a question. I didn't put it in chat because I just suddenly thought of it. I just recently did an advanced directive with my lawyer, and I think that I did here in Vermont, and I think that I did. One of the questions I did, it was included in do not resuscitate.
So depending on what you did, for example, our living will says that your surrogate can sign a do not resuscitate order later, but it is not a do not resuscitate order now. So if you signed it and the lawyer was there, if a doctor hasn't signed it, you probably did not do a do not resuscitate. Now, I can't say that for certain because you're in Vermont. It's an easy question they would answer over the phone for you. But yes, typically a living will is not going to include a DNR itself. It's simply going to grant the authority to do a DNR later. Okay, so, but you can check your document or check with your lawyer that, that should be something they're willing to answer for you without charging you. You can tell them I said so.
Okay.
So,
No,
but yeah,
she's a pretty good lawyer. She probably wouldn't charge me. She's
okay,
actually a
good.
friend of the family, so.
Good. All right. Yeah. So that's a question I would ask though, because it really is, do not resuscitate order is a very big deal in that if they didn't help you, you're gone. And many people that have them are not ready for that.
Mhm.
So the next document I want to talk about is a last will and testament. A will is standard for everyone, whether you have a trust or not. It is generally the direction to a court to how to dispose of your assets. So if you have a will, you will likely have probate. So a lot of people say, I have to have probate even though I have a will. Yes, that probate is the court process where the judge takes your will, hires a executor, we call it in Florida a personal representative, but hires an executor to work for the court to distribute your assets according to that document. That is different than a trust, which I'll talk about, where that same person, usually the trustee, does not have to work with a judge. So that's one of the big differences between a trust and a will, is whether or not a judge is involved in the decision-making process. Probate gets a bad name because the only ones you hear about are the worst cases. I cite here, that 95-year-old billionaire with his 21-year-old girlfriend. Those cases make it to court and they get litigated and drawn out for years, and we hear about them. Most probate cases are straightforward. They can take time. They can take, in Florida, it has to be done within a year, or you have to explain to the judge why it hasn't been done. Some of your states will not have as strict rules as Florida does, but generally that executor is held to account by the court or the beneficiaries to move that process along and get it resolved. It can be simple or complex. We have some very complicated types of wills here in Florida, and some very straightforward wills. So you have to know what's right for your circumstance. But the only thing that's going to be subject to a will are assets that do not already direct who is to get them. So if, for example, I have an account joint with my wife, that account would not be subject to probate, because when I die as a joint owner, she would automatically receive those assets. Or if I go and name my wife as the beneficiary on an account or a life insurance policy, when I die, the life insurance company already knows to give that to my wife. So that does not go to probate. The only thing that would go to probate are assets that do not have a beneficiary. So for many of you with relatively straightforward estates, I have 3 bank accounts. I can go and name all my children or my friends or my partner or my, spouse as the recipient of that account and avoid probate completely. So know that a will is only for those assets that do not have beneficiaries already designated. I mentioned here some Florida issues that just prove the point that you need, in many cases, internet documents are inadequate because you don't know what you don't know, right? You can answer all of their questions on an online form, but still not know what you don't know. And so things in Florida that trip people up, that go to places like LegalZoom or some of these other websites that ask you questions and answer it without a consultation. We have homestead issues. We have spousal elective share issues. We have unique tax issues. You all do too, different things, but all of your states have things out there designed to catch the uninformed and potentially change the plan that you had in place. So my suggestion is you're only going to do this once or 2 or 3 times in your lifetime, depending on how early you start planning. Pay the money, consult with a lawyer, make sure you are not a victim of unanticipated consequences. A lot of people go and they name that one trustworthy child, put them joint on a bank account, and then they die, and there's no obligation for that child to share with anyone. And even if they do share, they may have just made a tax problem for themselves, because now instead of you making the gift, let's say you had two kids equally and you left them $100,000. Instead of you naming them equally and giving them each $50,000, your trustworthy child was on the $100,000 account. Now she gives the gift to her sibling. Well, she has just made a $50,000 gift, which may impact her estate planning, her tax situation. And so doing this yourself is a bit like going to WebMD to diagnose your tumor. There are just things you don't know, and you should assume that you can find better support with a professional. And I know that's speaking to my own interest, but we see a lot of bad documents come through our office, and you don't want that to be you. Any questions about the will? I'm sorry, the will before I move on? No? Okay. And we're just about done. So I want to touch briefly on trusts. I am a maker and seller of trusts, and I tell people all the time, and they fight with me all the time when I tell people, you may not need one. There are people who need trusts, and there are people who do not need trusts. And a trust is almost never fully inappropriate for you. It's probably not going to cause you any harm, but you may be buying something you simply don't need. And many, many people who get trusts use them wrong. If you went to a lawyer, paid for your trust, came home feeling good about your decisions, put the trust in your lockbox, knowing that you're protected, and you never go and fund that trust, your trust has almost no purpose. In fact, you've probably created twice the amount of work by creating a trust than you would have if you didn't. That's because a trust, the way I like to describe it in layman's terms, is a trust is a robot that you are creating separate from yourself. So there's John Griffin and there's the John Griffin Trust. And in that robot, the way a trust works is the trust can't control anything until I give it the asset, right? So if I move $100,000 into the trust, now the trust owns it, not me, right? So the robot owns it. The benefit of that is a robot never dies, right? So if I die, the robot doesn't care because it just keeps living to distribute that money out to the beneficiaries, right? The trust document, the paper, is like the operating manual for the robot, and the trustee is the person with the remote control. So if you do not fund the trust properly, that trust has no benefit to you at your death. What you probably are going to do is have to probate your estate. The probate court is going to move everything to the trust, and now you have to administer the trust on top of that. So you've doubled the amount of work that's required to do it. So for many of my clients who I know are not going to follow through with that trust funding step, we do not recommend a trust for those clients because it is not doing them a favor to have to do that. For many people, naming beneficiaries may be a better option than a trust because they're more likely to take care of those things than going through with a trust funding. One exception to that rule generally is for those of you who own property in multiple states. If I'm, down here in Florida, we have a lot of snowbirds, right? So I'm 6 months here, 6 months Ohio, 6 months Pennsylvania. If I have a house in Pennsylvania and a house here, most of those clients are going to be recommended to have a trust to hold that out-of-state property so that we don't have to probate more than one place if we have to do a probate at all. So know that that is one exception to the trust rule that you want to consider. What I like to tell my clients, or what I'll tell you is when you are planning to go see a lawyer to do these things, try to have as many of these questions answered in your mind as possible, right? The most efficient thing for you to do is to go to that meeting already knowing kind of who you'd want to make financial decisions for you, who you're thinking you would want to make healthcare decisions, who would be in charge of your will or trust, who's going to get this money if you die, because that's going to be the most effective use of your time, being able to really talk in more detail about what is right or wrong about these people than saying, I don't really have names or suggestions, because that can really make that a difficult process to get the right information out. The other thing I would like my clients to know before they see me is think about contingencies, right? It's easy to say, I want everything to go to my children. But then I'm going to ask you that question when you're in that meeting. And what if your children aren't there, right? What if your children are deceased? Who's going to get it after them? What if that brother you named as a beneficiary, if my sister's on the line, if you name your brother as a beneficiary, for example, but what if I'm not here and you've got that next person, who you're going to give it to? If you're not close with a large number of people, which a lot of people aren't, don't have a long list, then we want to be thinking, is there charities? Are there, is the National Grange Foundation a good beneficiary of your estate or some portion of it, right? So I got that in there, Joan. So, you want to think about, are there charities, are there organizations that could benefit from your money? The other thing I like to encourage people to do is be thinking about, when you think about giving money to individuals, think in percentages, because we do not know what tomorrow will bring, right? We may have twice as much money or very little money. And so when you think of your beneficiaries in percentages, then you ensure that everyone you've thought of gets something. Because if you say, at least in Florida, I can't speak to every state, but I believe it's true in every state, is if I say I'm going to give $50,000 to the Grange Foundation, $50,000 to my best friend, the balance to my wife, and I die with $100,000, the Grange Foundation gets their 50 first, my best friend gets his 50 first, my wife gets nothing. And so when you name cash, what we call specific bequests, instead of percentage bequests, you can have a very unintentional outcome of your plan. And so make sure that you think in percentages. The other thing that we can do, and I do in some of my plans, is if I wanted to leave $50,000 to the Grange Foundation, I would say $50,000 to the National Grange Foundation, but not to exceed 10% of my estate, right? So the maximum they're going to get is 50, but if I end up dying with less than $500,000, their share is going to go down by percentage, so that I'm sure that my wife or kids get the majority of my estate. So it's a good way to be thinking, again, in percentages. Any questions about trust planning? Right? Really, we're sort of at the end. So any questions about any of the topics we've talked about, or something I didn't cover? I know I covered a lot, but no? Anyone
Well, it was
want?
fabulous for me. I'm telling you, I just think everything you shared with us is great.
Well, thank you. Thank you. Yeah, Joan, I can share this PowerPoint with you or someone else.
Phil, if
Oh,
you give
okay.
it to Phil, he is gathering up everything from what we're doing in Grange Month. And as he gets time, he'll be posting them on the National Grange. Well, wherever he says.
And
So
you know,
it would be to Phil.
okay. Great. Okay. I'm thinking the only question I have, I need to make sure that it's clear that it wouldn't apply to everyone that receives it, because I have to give my disclaimer. So just
And
give
you
me a
have
little while
a few
to.
questions that are popping in. You have
Okay.
questions.
Perfect. And let me just write down Phil's email here before I answer them, if that's okay, in case it drops off when we disconnect. Okay. So the first question I see up here is, if you have farmland, is it worth setting up a trust? That is in part going to depend on your state. In Florida, we have a process. If it's your primary residence, there's an abbreviated process for transferring that to your family, even if you don't have a trust. But in many states, that isn't true. So a trust, if your primary goal is to avoid probate, then a trust would be beneficial to you, to keeping that out of probate. So whether it's farmland or a city condo, if your primary goal is probate avoidance, then a trust would be worthwhile. When you look at the cost of probate, Generally, you're looking at somewhere in Florida around 3%. In other states, it's as high as 6%. And in some states, it may be less. So you kind of have to know what the rules are of your state to see how much economic cost it is going to be to probate if you don't have a trust. Sharon asks, can you explain what you mean by funding your trust? So in funding your trust, you are having to transfer ownership of assets from your individual name to the trust name. So for example, if I have a savings account with $50,000 in it, and every month I get that statement and it comes to John Griffin, then that is generally my account. It is not in my trust, even if I have a trust established. So you would want to work with the bank or the institution to transfer that asset from your individual name to your trust name, so that now the trust owns it. And when you die, that trustee would step in and administer that asset and make sure that it goes to the people who are supposed to get it. But if you have those assets in your individual name and there are no beneficiaries listed on that account, then it will not be in your trust, and you want to fund that trust with those accounts. Basically, that means taking your trust document to the institution that holds that money, let's say Bank of America. You take that trust to Bank of America, and Bank of America will work with you to fill out the paperwork to retitle that from your individual name to that trust name. And that is the trust funding process. Now, for a lot of people, I do want to say that you typically do not want to put, at least in Florida, check in your state, but you do not want to put an IRA into a trust, even if you have one. Most of the time, we're directing our clients, barring some specific circumstances, of course, not to fund an IRA into a trust. You are better off naming direct beneficiaries there. Let's say I'm naming my adult children. I want those children to be able to draw that IRA out over the longest period of time with the least amount of tax. And sometimes funding an IRA into a trust can have unintended consequences of additional taxation or a shorter withdrawal period. So talk to your lawyer before you move any IRAs into trust. But funding a trust really just means going to the bank with your trust and moving the account names into the trust fund, so that the next month, if I have that $50,000 account coming to John Griffin, the next month that statement might read the John Griffin Trust Fund with John Griffin as trustee. So then I'm going to know that account is now a trust account, not an individual account. Does that
Great.
answer your question?
Yes, thank you.
No problem. I see the next question was, if my mother-in-law is going to downsize and buy a smaller home, would it be beneficial to place that house in her name as well as her children's names? In this case, maybe 3 of them. The issue with adding someone on to a bank account or a property is that if I went and added my children onto my house, they are co-owners. So if I want to sell the house, I need them to sign off on it as well. But if they get divorced or are in a car accident or have any tax issues, don't pay the IRS, now what was my asset, the house, now belongs to them as well. And it might mean I get a lien on my house. It might mean they can force the sale of my home to pay that person from the car accident, or they may, my ex-daughter-in-law might get a share of my house in the divorce. And so the risk of adding that child's name to the house is they become a co-owner, which means all of the problems that go with your children may suddenly attach to your house, which can be a very big problem. The other issue is, from a Medicaid perspective, is if you add the children onto the house, at least in Florida and in most states, I believe, is now I've made a gift, right? So if I buy a $200,000 house and I add my 3 children to that house with me, but I'm the only one who paid for it, I've just made a $150,000 gift because I've given 3/4 of my house away to my children. And so now if I need nursing home care in the next 5 years, I would not qualify, because I made that gift to those children. And so you want to be real cautious in adding individuals to your home because it can have those unintended consequences. Now, in Florida and in several other states, there are 14 states that do this. There is something called a ladybird deed, or a retained life estate, or an enhanced life estate. They're all the same thing, but each state uses, some states use different terms. So ladybird deed, retained life estate, or enhanced life estate. That is a type of deed that allows you to name beneficiaries on your house, right? So I can say, the house is mine for life. When I die, it goes to my 3 kids. The benefit of that is you do not give away your house now. So there's no gift for Medicaid. You're not subject to your children's issues in most cases, right? If they get divorced or sued, but you don't have to probate the house when you die because it has the beneficiaries listed on there. They become automatic owners at your death. So you'd have to look at your individual state to see if they have a ladybird deed. That would typically be my suggestion over over joint ownership. Although I'm going to say, Ellen, you are in Pennsylvania, and Pennsylvania is one of the worst states in this country for Medicaid planning. So you absolutely want to talk to an elder law attorney before you do anything, because my understanding is not only are they very difficult with protecting houses, so it may make sense for you to be on the house in Pennsylvania. They are also the only state, I believe, in the country that can sue the children of a Medicaid recipient to repay the debt. They have what they call familial responsibility in Pennsylvania. And so it is possible that if your mother-in-law got Medicaid, for example, in Pennsylvania, they might be able to come after you to cover that bill. So my suggestion is you drive over to South Jersey, put her in a facility right over the border so you don't have to get stuck paying for it, because Pennsylvania is really one of the worst states in the country, as I understand it, for these benefits. I don't mean to be the bearer of that bad news, but often I'm telling my clients who have children scattered all across the country, because here in Florida, no one's from Florida. If you get sick, don't have your child just come and rush you back to that home state, because you may find that the rules there are very different than here, and it can end up costing you hundreds of thousands of dollars you wouldn't have had to spend if you got your care here in Florida. Does that answer your question, Ellen? I hope so. If not, chime back in. Okay.
Yeah, thanks, John. That was a great answer, although I'm packing my bags now to move out of the state.
Yes, unfortunately, we hear the horror stories around the country, and Ohio and Pennsylvania, you've probably gathered, are not at the top of the list of places you want to be getting long-term care, because they are some of the less kind states. Any of the smaller states too in the Northeast, for those of you in the Northeast, Maryland and Delaware, these are states without large tax bases. And so sometimes the benefits are worse there. Here in Florida, we have the advantage of, despite our taxes being very low, we get the benefit of you all bringing your vacation money down here and leaving it. And so we have a lot more ability to provide, even though it would not make sense because we have such a large population that needs these benefits. Because we have a large state with a large tax base, we can afford to provide more benefits than a lot of other states can. Joan asked, what about having joint checking, savings, and CD accounts with your children? Again, the same issues apply as they do with the house. Whenever you name a joint owner instead of a beneficiary, you are potentially putting those assets at risk for the child's issues, right? If I own an account jointly with my mother and I get sued, that money is half mine, maybe all mine, depending on how the courts look at it. And so there is a risk that some of that money could be then caught up in a divorce or a lawsuit. So it's usually better to name a beneficiary on the account than it is a co-owner in most cases. generally speaking. Okay. Suzanne asked, does that answer your question, Joan? Okay, thank you. So Suzanne asked, in California, Medicaid can go after the estate as well. It's very hard to get long-term care insurance if you are over 72 here. Yeah, so in Florida as well, Suzanne, we have the same issue, which is called estate recovery, meaning that Medicaid can go after an estate for reimbursement. So I like to tell my families, Medicaid is giving you a loan, not a gift, right? So if they have to loan you $500,000 to get nursing home care through your lifetime, when you die, they may come looking for it. The part of the planning that should be done with an elder law attorney is trying to make sure that there isn't money there to collect against, right? So in Florida, with the strategies that we use to get families on Medicaid, we're making sure that to the extent we can, there aren't assets left in that estate, by transferring, moving, retitling into allowable planning strategies. There shouldn't be money left in the estate to recover against. Now here, like I said earlier, we have also a huge benefit of protecting the house after death. But in some states, the house would then be subject to recovery if you died owning a home. So that may be a case again where having the house joint, to answer Ellen's question, right? Having the house joint more than 5 years before nursing home care may make sense because it may limit the ability of Medicaid to go after that money at death. So yes, it's definitely something you want to be thinking about with your elder law attorney based on the laws of your state, and also to be thinking about where you are likely to get care, right? So if we have this all the time in conversation with our clients, because many kids don't live here, I often ask my clients, if you needed nursing home care, where would you get it? And if the answer to that is, I would absolutely go back to Illinois to be with my daughter if I got dementia, then you want to be thinking about a plan with an Illinois attorney in mind, right? Because we can do all the planning we want here in Florida. If you're going to get your care in Illinois, our rules aren't going to apply. So it is important for you to think not only where you live, but where you anticipate getting care in the future. So that's a great question. Thank you, Suzanne. Any other questions I can answer for you? I know we went over the anticipated time, so I appreciate the patience of everyone who stuck with us.
Well, I see that you must have hit the mark because no one dropped off.
All right. Well, thank you.
We held together the 21 that are on, and some had multiple people in the same household. So it was a great turnout. Oh, there's a question just came in, John.
Okay. Yep. I see that one there. And just so you know, I did go to that last thing there. Obviously, a consultation won't work for most of you, but my website is there, has some information. It's not very detailed because of liability issues. We don't post a lot of answers on there, but there, like I said, that resource center offers a lot of links that you may find helpful, especially for VA, Social Security, things like that. Under that griffinelderlaw.com, the resource center provides a lot of information. Steve asked, do these documents ever expire? The answer is, again, without knowing every state's specific laws, the answer should be no, as a general rule. A power of attorney that is 10 years old, so long as it's durable, would still be valid. And we hear this all the time, unfortunately, from banks. Oh, we can't honor this power of attorney, it's too old. It has to be within 2 years, or you have to use our individual forms. Most of the time, that is not true. That power of attorney under state law is almost certainly going to be valid indefinitely and without having to use a specific form. So if you run into that problem, make sure that you contact a lawyer. If a bank says, no, this is 2.5 years old, that's too old, we don't honor it, that is generally not going to be the case. So the only thing I would, I guess, answer that additionally is, if your documents are old, they may not be up to date, right? So I mentioned in Florida, 2011, we had a big law change. So if you have documents from 2010, you might find that you are not up to date with the current law. And so we recommend to our clients, a lot of lawyers will say every year, every 3 years. I say probably every 5 years, or major life changes. Just call, have a short conference. Do my documents need to be updated? Have there been major changes that I need to worry about? So that you are looking at these at least every 5 years for changes in your life circumstances or in the law that would, make it appropriate to update them. Thank you for all the thank yous. I see a lot of you did that. I appreciate that. And again, if there's anything else, if not, I'll turn it back over to the National Grange Foundation.
Thank you so much, John, for wealth of information and sharing your expertise with us all who are novices at this and hope that we're doing the right things. So we greatly appreciate it. And for those of you on that want to share the briefing, which will be posted by Phil here in sometime later this month, it's a great opportunity for you to talk it over with your own estate planner or your elder law attorney. I didn't, that was new information for me to know that estate planners are different, but elder law, there's only 5 in your area and 160 some, I think you said, of estate planners. So that's, we have the real expert here. So thank you, John, very much. Anything else for the meeting? Well, for this time together.
Well, I just want to say from the National Grange, thank you to the Grange Foundation and the 1 in 1000 Club for sponsoring tonight's event. I hope you all got some useful information out of it. There is a lot more coming up here. It is Grange Month. So next week on Monday, and of course I don't have my calendar in front of me because that would have been really helpful. Monday is our new member forum with Amanda Brazana Rios. So if you have any new members in your Grange or in your area within the last year or so, please ask them to tune in and get some great information from Amanda. And then Tuesday night, the 12th, is going to be a great night. It's our community service forum with Pete Pomper, our community service director. And we are going to be spotlighting 3 Granges from across the country who are doing some excellent work in their communities. So that's all I have. So thank you all for being here tonight. I appreciate your time and look forward to seeing you all again soon.